UKSC and Paulley.
Mr. Allen.
Good morning, my lord, my lady, my lords. I appear on this appeal together with my friend Catherine Casserly, who appeared for Mr. Paulley at first instance. Mr. Chamberlain, leading Mr. Oliver Jones, appears for first. Mr. Chamberlain appeared in the Court of Appeal. Can I indicate at the very beginning the outline of the submissions that I propose to make in very short form? The chapter headings are Introduction, Issues in Appeal, some submissions on facts, submissions on law, a consideration of the judgment of the recorder, and a consideration of the judgment of the Court of Appeal, judgments in the Court of Appeal. We've an agreed timetable, and I've got to shoehorn that into the time between now and 12:20. So some of this I shall take quicker than other bits. And indeed, as your lordships and my lady will have seen, there's a degree now of agreement about what the issues are. And anticipating what will be said later on, the case that I have to meet is that the adjustment was not reasonable. And all other points that go to the duty, although they were argued below and were subject of debate at various different stages, have now been resolved.
Which adjustment was not reasonable?
My lord, which judgment below?
Which adjustment was not reasonable?
That, my lord, is the question that will need to be looked at as well. But you'll forgive me if I don't take up that opportunity to answer your lordship's question immediately. Can I start with the introductory remarks? Because there are some short points of importance for all of you in focusing on the issues in this case. And there are 5 short points under this which I want to make. Firstly, the overall importance of the case. Secondly, a question about common decency. Thirdly, the extent of the competition for a wheelchair space on a bus. Fourthly, the importance of travel for disabled persons. And fifthly, the importance of a practical application of the duty to make reasonable adjustments. The submissions are relatively short, but they will cover those 5 grounds. The importance of the case. This is the first time that this court has had to look at the duty to make reasonable adjustments. Lord Newberger, Lady Hale and Lord Clark have received some submissions about this in 2 cases argued in December 2014. They may recall Astor and Hotak. The 2 cases were heard sequentially, but they weren't called upon to construe and apply the provisions in any detailed way. The judgment as to how these provisions work will be important, therefore, for all disabled people, and indeed those that have to deal with them. The court may want to know roughly how many disabled people there are in this country who are potential beneficiaries of these rights. The best evidence we've got of that is in Authorities Bundle 4, which I invite you to pick up for a moment. And it's at tab 36, and there's a report that was conducted by the Papworth Hospital Trust into exactly these issues.
Electronic number?
It's tab MS 2152.
Thank you.
It actually starts the previous page, 2151. Papworth estimate 12 million disabled people in the country. If you come down to the 3rd bullet point, in 2012-13, the most common impairments that disabled people had were mobility, 57%. And then if you come up 4 bullet points from the bottom, the 2 most common barriers to work among adults with impairments are lack of job opportunities and difficulty with transport, 29%. And then on the next page at 2153, under the heading Health and Social Care, if you will go to the 5th bullet point, the majority of impairments are not visible. There are only around 1.2 million wheelchair users in the UK. That amounts to roughly 2% of the UK population. 28% of wheelchair users are under the age of 60. So that gives you an overall social context for the issues in the case. Now, secondly, a very short point about common decency. Common decency obviously has a place in society, and it is obviously a social good. But one of the major issues that disabled people, and wheelchair users in particular, have felt over many years before legislation was introduced to assist them was that their situation was seen as being invisible to lawmakers and to people who construct the working environment. And common decency did not, at that stage, solve their problems. They are always concerned when they are told that they are to rely on the common decency of others to assist them to the solution that they want. I make that as a general point because it underpins the fact that we are now dealing with rights given by Parliament and the effect of those rights and the significance of them in contrast to disabled persons' reliance on the common decency of others is at the heart of many of the issues that concerned disabled people, wheelchair users as well. Thirdly, the extent of the competition for use of the wheelchair space. The case has, in some parts, been identified as being about a competition between the rights of wheelchair users and travellers with children and buggies. But we say that is not the right way to view it. We do not suggest that parents travelling with buggies don't have the need for assistance or to be taken into account. We do not suggest that bus companies shouldn't consider about the general public as it is. What we say, and we'll go through this in detail, of course, in the submissions, is that we have a particular problem, wheelchair users, Mr. Paulley in particular, and we have been given a particular solution. And we do object to the solution to other problems being grafted on in some way that undermines the strength of the solution which we say Parliament has given through the various bits of legislation which are set out in the case. And we're supported in this approach, and indeed the recorder had this in mind. The biggest well-known forum for discussion of issues about parenting issues is known as Mumsnet on the internet. And the threads on Mumsnet were before the recorder dealing with this issue. There is no move amongst parents with buggies to say that they should have an equal or better right to this space. I'll give it to you for your notes. I don't think it's necessary to turn up, but this was discussed before the recorder. The thread is at Appendix 1, internal page 187, and MS number 462. And you can also see it in detail in Appendix 2, which is not in electronic form, as far as I'm aware, at page 529. There is, of course, the particular problem in this case that gave rise to the litigation. What there wasn't was any evidence before the court of the statistical need of parents with buggies. There was no research that was put before the recorder about their particular needs. What I can tell you is that some bus companies in other parts of the country have created different kinds of buses with designated wheelchair spaces and designated buggy spaces. It's not unheard of. In fact, it's quite common now in some places for buses to be amended and to work in that way. What Mr. Paulley did say, though, and I will deal with this a little bit later on under my facts heading, and I'll show you this specifically, is that he had real experience himself and amongst his community that he lived in of this being a problem for wheelchair users. There was evidence about a frequency of problem, not research evidence, but I will deal with that in due course. The next heading that I wanted to raise by way of introduction is the importance of travel, the ability to travel for disabled people. And I make this point having already shown you the passage in the Papworth Trust paper. But I want to do it in a slightly different way, not just looking at the economic advantages for disabled people being able to travel relatively freely, but there's also a point about personal dignity. We all know that travel is supposed to broaden the mind. There's a lovely quote from Seneca that says, "Travel and change of place impart new vigour to the mind." If you can't travel, or you're put off travelling, you become isolated. It leads to an inability to engage in community with family and friends and the wider world. Of course, you can use the internet and the phone, but personal contact is really important. And wheelchair users know this as much as you do, but they feel it more because of the difficulties that they have in travelling. All of us, from time to time, have had difficulties about transport. All of us, I suspect, either have had or know somebody who has had, for instance, a torn ligament, a broken leg, or some sort of surgery that has impaired travel. For us, in those situations, the difficulty is transient. But the point about being a wheelchair user is that the difficulty in travel is not transient. It is something that they're aware of every day, all the time. They can't leave home and travel without thinking about the difficulties and barriers that they have to face. If they go by train, they have to worry about the ramp turning up. If they come to this court, they have to be concerned that the lift will take them up 2 floors and take them down again and not break. And so all the time, travel is a significant issue. The difficulties with travel is a significant issue that impinges on the life of all wheelchair users. And we make this point by showing you the evidence that Mr. Paulley put in front of the recorder, and which was accepted by him, about the impact of this occasion on him. If you'll turn to Appendix 2, at page 582, you will find...
So this is not on the electronic file?
I understand Appendix 2 is not.
It is.
Well, then...
So what tab is it?
I need Paul's assistance, because I don't have MS numbers.
In any event, could I make it clear, Mr. Allen, that there are some of us who operate exclusively electronically, so it has to be on the electronic file.
My lord, I have heard you say that to me before, and I had thought that this was on the bundle, but when I got
But
my
in any
copy,
event, I think it is.
It
I
doesn't
think that
have
the
the
problem
MS.
is that we, for some reason, the appendices very often don't have the MS numbers on them, but they are on the
Then
memory stick.
it is, I'm afraid, a difficulty which I shall need some help from left and right.
Which is the tab number?
The page, I'm told, is
MS 859.
is MS 859, and I'm grateful to my friend.
And the other number?
And
582.
582.
the page, the paragraph I wanted to draw your attention to is paragraph 28 on internal number 582.
So it looks as if one has to add 277.
Yeah.
Right. Yep.
This is what he said. The whole situation has had a massive impact on my confidence. Shortly after this incident, I stopped using public transport as I'd lost confidence. It's a lottery as to whether I will encounter difficulties or not. I don't want to find myself in a situation where I'm put in conflict with others at worst or embarrassed in front of them at best. The space is at the front of the bus, which is in full view of other passengers, and having to argue for or justify wheelchair space just focuses on my disability all the more. It makes me feel like a second-class citizen. That was his evidence, and we certainly submit that many other wheelchair users would take a similar view about it.
Yep.
And my last introductory point concerns practicability. And you will need to consider, in due course, the conduct of this litigation. But this is a point about its practical application. These kinds of cases are not worth a lot in damages. Mr. Paulley was paid, or was awarded, £5,500 in accordance with a tariff of judgments which have standardised payments for injury to feelings, and there's no argument about that. But one can see immediately that the economics of litigating cases such as this, where their worth in money is relatively small, is a seriously difficult issue. The extent to which an individual can adduce evidence of all the aspects of a service provider's business and anticipate all the kinds of problems that might arise has to be seen in the context of the actual value of these cases and the capacity for those kinds of points to be raised. He was not assisted at first instance by the Equality and Human Rights Commission. It has a limited budget. It can't assist in every single case. It has assisted and does assist in the Court of Appeal and here. But we submit that in approaching the legislation, you've got to bear in mind its practical application by county court judges with litigants that may be litigants in person and certainly will not be able to have legal aid automatically to argue these cases. So those are our introductory points. Now I want to say something about the issues in the appeal. And you will have seen that there is some dispute in the respective cases about how this court should approach the case. Our primary submission is that the question for this court is whether the recorder reached a correct decision. The way we have put it in the SFI, and we insisted on it being formulated in this way, was whether the recorder was correct in concluding that the respondent was in breach of the Equality Act. And we've put it in that way because, as you will hear in due course, we've had to face arguments and factual scenarios which were not adduced before the recorder and which we could not deal with in cross-examination, nor did we have an opportunity to anticipate them and deal with them in evidence from Mr. Paulley. And that is why, in due course, I shall be focusing specifically on how the recorder dealt with it. And anticipating our submissions, they will be that he did real practical justice between the parties, and his judgments to be commended and upheld as being sensible in the context of the debate that he had in front of him. On the other hand, there are now 4 different points which are taken against us on the question of reasonableness in the respondent's case. I'm going to characterise them shortly at the outset here so that we know what we are talking about. And I will give you the MS numbers as we come through them. The first point, they say, is that wheelchair spaces were designed to be shared. That's MS 124.
Yep.
Secondly, my paraphrase of the submission, the recorder's judgment didn't take sufficient account of the rights of, or the position of others, MS 127. Thirdly, that the recorder's approach was unreasonable because it would give rise to confrontation or delay, MS 131. And fourthly, that it was not enforceable. It was both impossible legally, it is submitted by the respondents, and very difficult practically. And that is MS 133.
Right, thank you.
And we reply in summary to this. We accept, of course, that the wheelchair space can be used by others when not required for wheelchairs. To that extent, it can be shared. To say that it was anticipated it should be shared answers this case not a whit. The key point is that it was intended and introduced to meet the needs of wheelchair users. Secondly, on the issue of not taking sufficient account, the only difficulty that was specifically put to the recorder was dealing with the precise situation that gave rise to the conflict on the 24th of February 2012. None of the other examples that have been put forward in the Court of Appeal judgment were advanced. Not one of them. Had they been, we would have made submissions about them, and we might have thought about how they had to be dealt with. There's a subordinate point to that I will deal with shortly, which is that the council then instructed for the respondents first, specifically asked for the case on injunction, the argument on injunction, not to be dealt with, because it may be necessary to adduce further arguments and to consider further situations. It was at his request that the recorder put over the issue of injunction. If the recorder at first wanted to adduce further difficulties that needed to be considered in some way in modification of any mandatory order that the recorder might make, first had an opportunity and indeed reserved its position on it. That's the right place to do it. That is practical justice, not to start introducing them in the Court of Appeal and essentially trying to bring them in as if they're winning points, which we can't deal with in context in front of the recorder on the evidence. Confrontation or delay and not enforceable. Now, as I shall show you in due course, when I go to the judgment of the recorder, there were very measured submissions made about the kinds of adjustments that ought to have been taken and which were reasonable. And the principal purpose of those was to deal with a problem which lies, in one sense, at the heart of the fact of this particular case: conflicting expectations about rights on the bus. The whole point about those submissions, which were accepted by the recorder, was to change the balance of expectation when passengers went onto the bus, and therefore to diminish confrontation, and by diminishing confrontation, to diminish the need for delay. But we always accept that at the end it would be necessary, if there was somebody who utterly refused to accept the proper order of expectation, that the wheelchair user had the prior claim to the wheelchair space, we always accepted at some point something would need to be done to enforce it. And that brings us to the last point. It said it's impossible legally to enforce priority and very difficult in practice. And our submissions, which we will make to you, is it's not impossible legally, and it's not that difficult in practice. The recorder, as I shall show you in due course, was shown how contractual terms were introduced by other bus companies, which were much stronger and gave priority and indeed made it clear that there would be a problem if you brought, for instance, unfoldable buggies onto a bus. So point 1, terms and conditions could be changed, and point 2, we say that the conduct regulations, properly understood and applied, gave real powers to practically enforce the priority for the wheelchair user. That's a summary of the issues that we will need to bear in mind as we go forward. And now, some points about the facts. There are 5 headings that I want to deal with under this part. As the court will already have seen, there are some disputes about actually what the facts were, and there are some points about this which need emphasis in order for this court to get to grips with the issues that arise. The first point, just for your list, I want to show you the plan and photos of the bus, so we really know what we're talking about. Secondly, I want to show you First's policy on wheelchairs, and to say something about that. Thirdly, I want to show you, just reordered these in my own list, so sorry. Thirdly, I want to show you the evidence about whether the woman's buggy folded or not. You will have seen in my friend's case that it's argued that this was an unfoldable buggy, and there's some evidential issues about that need to be shortly addressed. Fourthly, I want to show you the comparable policies of Lothian and Stagecoach. And fifthly, I want to say something about Mr. Birtwistle's evidence. If I can start with the plan and the photographs, you'll find them in Appendix 2, and I'm going to need the assistance of my friend on this again. I'm afraid it's internal numbering, page 607, and I don't know if that could be helped by Mr. Jones. 884.
Yes. That's what it ought to be. Yeah.
277 is what to be added,
Yeah.
which I can easily do on my feet.
Well, you shouldn't have to.
My lord, you're entirely correct, and I don't know how that's gone wrong, but I'm afraid that's where we are. The court will go, first of all, to 837 on the MS numbers and 610 on the internal numbers. There is a layout of the bus on the ground floor.
837.
If I've got that right.
It's 887.
837.
It's 887.
887.
Yes. Thank you.
We'll see these in the photographs in a moment, but the one thing that you won't see much of is that you can see opposite the wheelchair space is 2 single seats, and then behind it you'll see that there are 2 double seats that are referred to as well, and I'll just have to say a little bit about that.
Yeah.
If you can turn forward next to internal 618, and that should be 895. You will see the door in. It's a single door bus, not like a London bus, with the wheelchair sign on the outside. And then if you'll turn over the page and to the next 2 pages, you'll see the signs that are fitted at the driver's door.
Yeah.
And these don't say anything about the priority for wheelchair users at all. You'll see that they do specifically deal with buggies. No more than 2 unfolded pushchairs in the space provided.
Yep.
Now, I pause there for a moment because it's inevitable that somebody who comes onto the bus who's not a wheelchair user, not thinking about wheelchairs, will see that if they're a buggy user or have a buggy, and will think that they have some priority to that space because of what it says. Over the page, the numbers, this was a 64-seater, and you can see it's 27 standing.
Yeah, we can see that.
The wheelchair space occupies 5 people can occupy the wheelchair space. Below that, you will see a picture of 2 seats with a small sign. Those are statutory seats, those 2 seats, and I'll explain that to you shortly. And you will see the sign on the next page, please give up these seats if disabled people require them. And then below it is the wheelchair space itself.
Yep.
And over the page you can see the sign, and it simply says, please give up this space if needed for a wheelchair user.
Yeah.
So that's the extent of the signing that was relevant in this case.
That's the notice that we see at
On the
bottom-
window.
on photo 13 on the window, is it?
Yes. And then some general views of the inside of the bus on, I think it's 901. And if you could go forward about 4 or 5 pages, you'll see some pictures at 631, I've got to add 277, 908 on the MS. You'll see pictures of a wheelchair in situ and how it fits in. I don't need to take you through all of those, but you may want to just skip through them. Those photographs were in a witness statement which was adduced, but there was no cross-examination on it, inevitably, at trial. Then the policy on the wheelchairs. And I want to make this first general submission that the respondents seem to point in 2 directions as to exactly what their policy was on wheelchairs. Firstly, and this is important because there's a point taken in the respondent's case for your notes at paragraph 20, little Roman 1, at MS 113, saying that our case at 135 that requires amendment. The point at 135 that they say requires amendment is where we said that wheelchair users were never told, or passengers were never told, that wheelchair users had priority in the designated wheelchair space. We stand by that completely. Now, you've seen the signs. The signs say, please give up. They certainly don't say that wheelchair users have priority. And the evidence that the respondents adduced was positively that wheelchair users do not have priority. This you will see again in Appendix 2, and it's at 868. In the evidence of the driver, it's page 591 on the internal numbering.
Yeah.
And if you can turn forward to paragraph 24, this was the driver's own evidence to the court. Wheelchair users do not have priority over pushchairs and buggies. This is clearly identified within the policy. At first, I'm aware I can approach and ask passengers to move positions within the bus so as to make space available within the dedicated wheelchair buggy area, but if they so refuse, I can do no more than ask. So that was the driver's understanding of the policy.
Is it you saying that was the policy or the driver's understanding?
Well, I say it was both of those, and I'm just going to show you the actual policy itself, and it was never suggested that the driver had got that wrong. Your Lordship looks puzzled.
Well, Anyway,
That is exactly what he said,
No, I
and that was the
understand.
policy that was applied and which led to the confrontation.
I understand that's what he said.
Your Lordships will see, will want to know what the policy itself said, and the policy for First Bus is at the very beginning of the appendix part 2, 392 on the internal numbering. By my arithmetic, that is 669 on the MS number.
Is this a published policy?
This is as best as we could get to what the published policy was.
Is it published?
It looks like it.
But will you bear with me for a moment? I'll just check with Miss Castley.
Well, it looks
Yeah.
as if it's on a website. Presumably it's a publicly available one.
Yeah.
But maybe it isn't.
This is all we've got. Yeah.
It seems to be.
2013. No, my lord, my lady, the first document is dated to 2013.
Yes.
And that was on the website after this incident. This is an amended version on the website, and there was some evidence about the amendment of it.
The judge's finding was that the change was made because the earlier statement was not thought properly to reflect the policy of the company.
And then he said, but it doesn't make any difference.
That's all paragraph 4 of the 5 of the judgment.
Exactly so.
Well,
But-
it's all set out there, isn't it?
Well, that bit it is, but what I actually wanted to show was the policy itself that the driver was trained on, which is what follows in the Appendix 2.
Yeah, again-
Don't want to take any great time over it, but
Again, it's all. I think it's in the judgment.
my lord, it may well be that you think that, but I think it is helpful to the court to see where it is in its fullest sense. If you'll turn forward, the policy that the driver had to learn, i.e. what they were taught,
Page.
internal 393, 394, and then add 277.
It's all right, we've got it.
We've got it. And this is of some significance, perhaps it's not dispositive of the case, but this policy was made before the duty to make reasonable adjustments was introduced. So it was made after the amendment to the accessibility regulations, but not with an eye to the duty to make reasonable adjustments. And you can see the date of it, it's September 2004.
Yes.
And the policy is there set out.
Yes.
And I don't need to take any more time over it there. As your lordship says, it's dealt with in the
Yeah.
in the judgment.
307, page 307. Yeah.
Exactly.
Yeah.
Then the question of whether buggies folded or not, whether the particular buggy folded or not. And my lord, this has been part of the respondent's case. They rely on the fact that this was, they say, an unfolded buggy. And they complain because in our case we say that there was no other evidence that it was not capable of being folded. Well, I suppose I'm partly guilty of an ellipsis, but I want to just tell you exactly what the evidence was. And I can do this by way of the note, of giving you the references, perhaps, without taking you all of this through, except at one place. It is true, Mr. Paulley, in his evidence, his written evidence, his witness statement, said, and it's at Appendix Part 2, paragraph 14 of his statement, page 579, and that's MS 856.
Thank you.
The lady who was on her mobile phone responded by saying that the pushchair did not fold down and so she would not move. That was what he said in his witness statement. Now, when it came to the hearing, he was questioned about this by the recorder. And although I don't know whether he's got his loop on at the moment, he does normally use a loop and is slightly hard of hearing. It's part of his disability. And the evidence that he gave to the recorder, which you'll find in the transcript, MS 412 at page 135, is, "I honestly cannot remember, because he, the driver, Mr. Brickliff, was facing the lady. It was difficult to hear clearly what was said." So the recorder quizzed him on it, and he said he couldn't remember, and he couldn't hear clearly. The evidence from Mr. Brickliff, the driver, was given in his witness statement at paragraphs 44 to 46, page 594 on the in Appendix 2. That will be
592, you say?
594. Sorry if I said 592, that was an error. It's 871, I think, on the MS. And his evidence was, "I politely asked the lady if she would be able to fold her buggy up so that Mr. Paulley could travel on the bus. The lady pointed out to me that her child was fast asleep within the buggy and that she'd no intentions of waking the child or removing the child from the buggy. It was clear to both me and Mr. Paulley that the lady was refusing to assist." So he did not give evidence that she said it was unfoldable, but referred to the child being in the buggy. And the recorder, we say, plainly accepted Mr. Brickliff's evidence. He didn't refer to Mr. Paulley's witness statement. He found at paragraph 3 in his judgment, MS 306, "The driver of the bus, Mr. Brickliff, in accordance with what was the defendant's policy, asked the lady to move by folding her pushchair in order that the claimant in his wheelchair could use the wheelchair space. The lady refused. Mr. Brickliff did not consider that he could do any more or require the lady to vacate the space. He informed the claimant that he would not be able to travel." So there's no finding that the buggy was unfoldable. And although I have to accept that there was something in the witness statement of Mr. Paulley, he went back on that, as you can see from the cross-examination.
Do we have any other evidence of what the buggy looked like?
No, my lady, we don't. But what I can tell you is that we have, for what it's worth, and this doesn't, I have to say immediately, this does not affect the determination of the specific appeal that is in front of you, but it may be of relevance generally. We've researched Mothercare and John Lewis online, and of over 200 different kinds of buggy, all of them either fold or, and this is the technical term, detach and collapse.
So what's all this got to do with the issue before us? Nothing.
Because one of the issues that is being put forward is that a mother with a buggy which cannot be folded has a better claim to the wheelchair space if a wheelchair user is coming up. And that the arguments that were put to the recorder and the recorder's judgment doesn't adequately take into account their situation. Now, what I can tell you is that there was no further evidence about the amount of occasions on which buggies are presented to buses in unfoldable form or anything of that kind.
Thank you.
It wasn't the case for the respondents that we have a particular problem in dealing with unfoldable buggies, because that's what they are. I suspect at some time that all of us have been active parents of very small children, although we may have been grandparents and so on. The phrase detach...
Or both.
It's got to be one without the other.
that moment in the argument when a little levity was needed, I think. What I was going to say is the phrase, as I say now, is detach and collapse, because very often buggies are constructed so that you can take the child in its container off the buggy, put them in the car, and put the seatbelt directly around it without moving the child. So there's quite a lot of technology out there about how that works, but there was no evidence about particular difficulties of that kind that was in front of the recorder. So much for buggies. Comparable policies. Now, these are important because Ms. Casserly, who argued the case below, showed that there were a number of different other policies. You will see them referred to if we need to go through the submissions that she made, but there are two which I want to specifically draw to your attention. And I preface this by saying we think that the recorder has made an error at one point in his judgment, referring to Transport for London's policy when in fact he meant Stagecoach's policy. That accords with the submission made by Ms. Casserly. The two policies, first of all, Lothian's is in Appendix 2, and it's at page 506 or 783.
Yep.
The court's very impressed with my mental arithmetic. But,
I'm not impressed by the need to. But
the Lothian policy that we have here is dated April 2012, so it is in fact just a few months after the incident in question. And there are two passages that I just want to draw to your attention. First of all, under the heading Conduct of Passengers. And you'll see in particular, it says passengers who break these rules must give their name and address to the driver when requested and may be obliged to leave the bus by a company official or a police officer. Now, of course, this document can be read in a number of different ways. It could be said that only refers to paragraph 2, but that's not how we read it. We read it as applying to the whole of the conditions of carriage. And that paragraph reflects, as we shall see later, Regulation 8 of the Conduct Regulations, which makes a provision of that kind. And then you'll see there are various bans that aren't allowed to take place under Conduct of Passengers. And then under the heading Accessible Buses, they have some quite detailed provisions under 3.1 dealing with wheelchairs and under 3.2 dealing with travelling with young children. 3.1, all of our buses have dedicated wheelchair space. And then you can see that the standard of the size of that, and that's set out in the Public Service Vehicle Accessibility Regulations, and that's referred to in our case. And so wheelchairs beyond that won't fit in. And then you can't take wheelchairs which are too big and so on. And then you can see over the page, last sentence, whenever the wheelchair space is needed by a wheelchair user, other passengers must move to make it available unless the bus is full.
Sorry, where do I find that?
Just above 3.2.
First column.
First column on the second page of conditions. Last sentence. Is my lord with me?
You have to move the thing across, possibly. Yes, no.
So Lothian have a defined priority policy. Not quite as good as we would want, but it's certainly better than First.
What, not as good because of the words unless the bus is full?
Exactly so, my lord.
Yeah, thank you.
Rather more is said 3 paragraphs further down.
I was going to take your lordship to those. And then at 3.2, travelling with young children, there's 2 paragraphs that are relevant, but I'm not going to read under that. And then on the third, in common with all other passengers, whenever the wheelchair space is needed by a wheelchair user, passengers with unfolded buggies must move to make it available. In order to allow wheelchair users to board, any passenger occupying the wheelchair space with an unfolded buggy should fold it and place it in the luggage rack. Alternatively, they may choose to get off the bus, in which case a receipt will be issued to allow them to complete their journey on a following bus free of charge. Now, it doesn't say so in terms, but the clear implication of that is that if you have an unfoldable buggy, you're going to have to get off. So that was Lothian's policy. And then Stagecoach's policy is 2 pages further on at internal numbering 510, and that will make it 787.
3 pages. Yep.
I don't know how big Lothian is, but my researchers tell me that Stagecoach has over 20,000 employees and 7,000 buses, so it's a pretty substantial organisation. And these are the conditions of carriage, and yes, these are the conditions of carriage as they appeared at the time.
Yep.
And you'll see conduct of passengers. We reserve the right to refuse you entry or require you to leave our buses or premises at any time should we have reason to believe that your behaviour jeopardises the safety, security and comfort of others. So they reserve a contractual right to eject if others' comfort is affected. Now, it's a general proposition.
Yeah.
Then they set out a number of bullet points. When travelling with us, you must in particular. And it's no secret that those are largely lifted from Regulation 6 of the Conduct Regulations. Foot of the page, if you're in breach of these and other statutory regulations, you will be obliged to give your name and address. So it's similar to the passage you've seen in Lothian as well. And we also reserve the right to take any other measures we consider necessary to protect the safety and comfort of our customers and staff, including temporarily or permanently banning you from travelling with us following an incident of misconduct. And then over the page at 5, carriage of wheelchairs, small prams and buggies.
Yeah.
And this is the policy which is very restrictive for and advantageous to wheelchair users. We're constantly investing. Wheelchairs, approved mobility scooters, small prams and unfolded buggies may only be carried on suitable low-floor vehicles, the use of low-floor on timetable and so on, subject to space being available and the discretion of the driver. And I do invite you to note that point, because one of the points that's been made here against us is that drivers can't exercise discretion about this, but Stagecoach have no difficulty. We will carry small prams and unfolded buggies on low-floor buses within the designated area. Prams and buggies must not block the aisle of the vehicle at any time. And then in bold, you are, however, required by law to ensure that the designated wheelchair space is made available if a customer wishes to board with a wheelchair or approved mobility scooter. You're required to cooperate in allowing proper use of the designated wheelchair space by vacating this space if it's required by a customer in a wheelchair or approved mobility scooter, including repositioning small prams, folding any baggies, and storing them in the luggage space. And although it was not available to the recorder at the time, bearing in mind the arguments that have been put in the Court of Appeal, that it's all too difficult and going to give rise to too much confrontation, and it's all unenforceable to take an approach similar to this in Stagecoach, we invite you to look at tab 32.
Is it right to say it's required by law?
It's certainly right, we would say it's right that it's required by law in relation to wheelchair users because of the argument that we've advanced. In relation to mobility scooters, it's slightly different. There is no present law that says that buses must have a designated mobility scooter place. What has happened is that a practice has built up with wheelchair mobility scooters being of a particular, there are various different sizes, but you can get a size and you can go to a bus company and say it's the proper size, it will fit in the wheelchair space, and then you can get a particular written permission from the bus company to say that your mobility scooter fits that space. So that's dealt with under the Equality Act by a particular series of reasonable adjustments that are made. I should add that there has been no issue or discussion about mobility scooters in front of the recorder, or indeed in front of the Court of Appeal. That's right, isn't it? There was, I'm sorry, and what did you say? No. Ms. Castley corrects me to this extent, that there were some questions about mobility scooters for the driver and how he dealt with those, but that didn't signify in the submissions from the other side. I can take you to that if necessary. So, to the answer, my Lord's question, we say it's right because of the reasonable adjustment duty and because the space is designated in the way that it is. But what I was going to go on to show you is Authorities Bundle 4, and I will give the MS number in a moment, tab 332, MS 2084, are the most recent version of the stagecoach terms and conditions. And if you'll turn to paragraph 5 of them at 2084, they essentially replicate, there's a few other added things in that I don't need to draw to your attention under 5, but there's a particular sentence I want to draw to your attention. If you see the passage in bold, which repeats what has been said, and they've gone on to add, failure to comply with this requirement will comprise a breach of section 3 above and may lead to further action as set out in that section. So Stagecoach have actually gone further in expressly stating what I think is implicit in the earlier version of the regulations, that they will deal with disputes about these issues, about giving priority to wheelchairs, as they deal with other matters under Regulation 3. Made it expressly clear in their policy.
What's the date of these?
My Lord, my Lady, we'll get that, I think, from the index to the authorities.
Okay.
And 30.
Oh, it says 2016.
Thank you.
Page 2086.
Now, I've taken some time over all this because another one of the so-called factual corrections in my friend's case at paragraph 20E is that we were in some way wrong to say that the recorder was right to find that others had a priority policy, quotes, with teeth. We would submit that looking at both Lothian and Stagecoach, you can see perfectly well that there were policies which really did have self-evident teeth on them.
And what was the date of the previous Stagecoach?
That was contemporary with the, or at least it was contemporary with the hearing. Whether it antedated the events of the 24th of February 2012, I shall have to answer after lunch. But it was in front of the judge. That particular policy was in front of the judge. And I want to make a short point about this. There was no evidence adduced, even though these were expressly relied on that these policies would not work or would cause particular difficulties that couldn't be foreseen or dealt with. When the recorder heard the case, he was shown the policies and they were relied on by Miss Castley for what they are as they state on the face of the documents. Of course, there could be issues about how bus companies choose to enforce terms and conditions. Different bus companies may take different views about whether it's enough simply to have the terms and conditions or whether they want to take the further steps of banning people or fining them or actually how they implement them in policy terms. But there was no evidence about that.
Might it be said that if that's right, that there's a range of attitude they could take on that sort of policy, there's a range of attitude they could take on how peremptory or to be. I think the point was picked up in Mr. Birtwistle's evidence, wasn't it?
Oh, absolutely so, my lord. And I don't want... it's not our case. Mm-hmm. It's not our case that... if I can put it this way, that a driver should never exercise any kind of discretion. It was never suggested like that.
No, that's not quite the question I'm putting to you. What I'm putting to you is a slightly different question. You accept very properly that there's a measure of discretion in relation to the, if discretion's the right word, judgment or matter of policy.
Yes, we can...
where you describe it, may it be said that could it be said in a similar way, as a matter of policy, how strongly you express the instruction or the suggestion or the request to people who occupy the space that's dedicated to wheelchairs, because in this case, for instance, yes. I think it was Mr. Birtwistle who gave evidence that the defendants in this case had considered that issue, and they were considered it was more effective to express it as a request rather than an instruction.
I shall have to come to the detail of that in a moment, but it's a general point my lord puts to me. And
well, our answer ties into what you're saying.
It's a general point my lord puts to me, but I answer it very shortly in this way. The case that we advanced was that steps needed to be taken to change the culture. And if those steps are taken to change the culture, with, of course, these terms and conditions or something equivalent to that, there is a journey. When you start changing the culture, you may want to be less demanding than when you've taken time over it. But the point that was made, that was nothing had been done to change the culture.
When you say changing the culture, you mean the culture of people like the woman with the buggy? Do you?
My lord, in short form, yes, I do mean that. I mean that making it clear that there really is priority for wheelchair users in that space, and expressing that in a series of different ways, which I'll show you in the judgment, exactly the points that were being made by Miss Castley.
Is there any evidence that this particular woman's attitude was characteristic of the culture that prevailed at the time? I mean...
Well, that's a question about how frequently or in what other circumstances these kinds of issues had arisen. And the evidence about that, which I'll show you in a moment, was that when Mr. Paulley had gone back to the Leonard Cheshire home where he lived, he discussed it with his fellow inmates, and they said it happened all the time to them. That was the evidence that he gave. And he was not, it was hearsay, and he was not cross-examined on it, but that was the evidence that he gave. So, I mean, if your lordship is asking, was there evidence of detailed research of the nature of these conflicts, the short answer is no, there wasn't. But equally, no point was taken that this was an atypical kind of response. In short, as I've shown you from the signage itself is confusing, because the signage, the first sign, you see, if you're not a wheelchair user, when you get on with your buggy, as I've said, is that there's actually room for 2 wheelchair users. And so there was a whole series of steps which were said that could be taken. To go back to my lord's in the chair's point, I readily accept that if you are in a process of changing culture, if that is an adjustment that you make, How you do it can be the subject of debate and could be the subject of argument. I mean, if for instance, First's case had been, we wish to give real priority, so that priority means priority. We're trying to educate the public, that priority means priority. We've started on that, and we've changed the terms and conditions, and we will in due course kick people off buses and ban them if they don't understand what our policy is and argue about it. But we're not ready to do it quite yet. That would have been a very different case from the one that this recorder had to deal with.
Thank you.
Now, these points tie in with a point about the burden of proof, which I will pick up when I get to the law, and about the practical application of this legislation. Because there is a reverse burden of proof in these discrimination cases. All that the burden was on Mr. Paulley was to put forward what were prima facie reasonable adjustments, and he did in a catalogue of them. And if they are prima facie reasonable, then the burden is on, and it's not just an evidential burden, it's a full persuasive burden, is on the respondents to answer the case. And my Lord's point, if it's to be said that there was a particular difficulty with a particular woman, or this was so infrequent as to not to matter, that's the place where that case could and should have been advanced, but was not. I now want to just pick up on the point about Mr. Birtwistle, because my Lord Neuberger raised it quite properly about the extent of his enthusiasm for change. And there are really two bits about this evidence from Mr. Birtwistle. The first is the extent to which he, or what the relevance of his evidence of what might be called the softly approach. There was some evidence about that, and I'll take you to that in a moment. There was also some evidence from Mr. Birtwistle about his enthusiasm for amending the terms and conditions. And you'll remember, you'll have seen that in our case. And my friend again says that this is a factual error that needs to be corrected. We say not at all. Mr. Birtwistle made it perfectly clear that if he could change the terms and conditions, he thought it would be a relatively good idea. If we can deal with the last point first, at MS 437, we have the transcript of the evidence, and you can see how that passage, that bit, went.
Which page again?
MS 437.
Yes, thank you.
And this is in the cross-examination of Mr. Birtwistle.
Yes.
And you can see at the top, it opens with the end of an answer to a question which starts, which is an argument between Miss Castley and him as to whether they really do have a priority policy, and it concludes it's intended to be obligatory. But it doesn't make clear that the space is actually intended for wheelchair users, does it? I would contend that it does. It has a symbol, and it says, please give up this space. Therefore, there's no requirement for the passenger to vacate it if there's no wheelchair wishing to use this space. But if it's not working and passengers are not giving up the space, why not have something more directed for wheelchair users? I think it's fair to say that in the majority of cases, passengers do comply with the notice of a reasonable request from the driver, in the main, clearly not in this case, Your Honour, but in the main. So what do you do for those occasions where they don't? This is where we have in common, I would suggest, with all bus operators, a problem in that our drivers are instructors, indeed driver Brickliff did in this case, to request anyone occupying the space to vacate it. If that passenger refuses, there's no actual sanction we can remove from the passenger from that space. We have no power under law to remove a passenger from the space who is not a wheelchair user. No power under law? That's correct. This is an answer to the recorder. If you had a power under the law, would you use it? I believe we would. We would certainly make use of the fact that the power was available and say to the passenger, you're breaking the law by not moving. And then they got into a discussion of the conduct regulations. And with Miss Castley and so on. And so it's absolutely clear that as far as Birtwistle is concerned, he thought there was nothing they could do, and but he was perfectly clear that if there was something that could be done, that he would have wanted it to occur. We see no factual error at all in our case, therefore, in saying that the evidence before the recorder was that Mr. Birtwistle would have liked to have been able to have a real power to, as it were, give real priority to wheelchair users. So that's the first point on Mr. Birtwistle. The second point is on his evidence about the stronger policy. And if you'll just turn a couple of pages forward to 439, funnily enough, he goes on at between E and F. I think you've already said it would be feasible, or certainly possible, for drivers to treat a refusal to leave the space as an act of nuisance under the driver conduct regulations. And he says, yes, it would be possible. There'd need to be clearly, in any case, a judgment which could be potentially coloured by other passengers on the bus. You can imagine full bus, and so on. And so then further questioning about the feasibility about that. Then finally, in his evidence, the gist of it, and I've just lost the place for a moment, is that his evidence on having the softly approach.
436.
436, thank you. And Ms. Castley asked whether there'd been any review of the effectiveness of that approach, to which he answered that there had not been. And that's at 4...
Oh, well, wait a minute. You haven't taken us to...
I'm taking this too quickly. At 4...
You haven't taken us to his evidence as to the policy, which is at page 436, which precedes...
My Lord, it is.
Which precedes the passages you've taken us to.
I'm perhaps taking this a little bit too quick.
But I think you're just taking the wrong order. I think we should start at 436.
I'm sorry, my Lord, if I've done it in the wrong order, but there it is.
I mean, the questions that you have followed on from what he said about the policy, it isn't very specific, but he does...
Exactly so.
Well, even so, we should see what he said.
I mean, the gist of it, if I can summarise it in this way...
Well, can we just look at what he says, since you've looked at other answers, at the bottom of 436?
There's a particular reason why it's a request. I'd not
We can read it to ourselves.
my Lord, at 436, he is saying his evidence is that they took the view that they shouldn't put negative notices up in summary form.
Well, they undertook a review, yep.
He was then questioned about that,
Yep.
as to whether there'd been any review about the effectiveness.
You were going to take us to that, which you say is at 439.
Exactly, my Lord.
Yep, very well.
And the answer to that was no, they hadn't, and nor had it been considered in the context.
Where do we find that, please? You say 439.
Bottom of 439, ever given consideration to be more specific, please, which steps the notice, then the top? Well, any of them. The notice, as I said a few minutes ago, the decision was then taken deliberately to try and make the notices overall on the vehicles more passenger-friendly.
Yep.
Was this all of your notices? Yes, indeed. Just a general marketing and communications issue? Yes. Not specific to your obligations to disabled people and specifically wheelchair users? You're familiar with the provisions of the Quality Act, presumably, absolutely. You're familiar with your obligations to make reasonable adjustments. You're familiar with the fact that your obligations are anticipatory. You're familiar with the fact that you must keep your obligations and your duty to make adjustments under review. It's an ongoing duty, so presumably you consider them regularly, do you? Indeed we do. So when was the last time you consider how these notices were working? I can't answer that question. Because you have not, I do not know, it's not something that I would have done as part of my responsibilities.
Yep.
I suppose I can justify taking that last because the key bit of evidence is at the end of his. But that's it. So, I mean, of course there was evidence that there are good ways to talk to customers and bad ways to talk to customers. And we don't disagree with that. But in this particular case, none of that had been kept under review at all, or at least there was no evidence that it had been kept under review.
I see, in relation to the question that Lord Sumption asked a few minutes ago about culture, it may not be the only relevant passage, but I happen to notice a passage on page 428 between C and F, where the bus driver is asked about how passengers respond to requests.
Your Lordship's voice dropped a little bit.
There's a passage at 428 between C and F where the bus driver is asked about, essentially about how passengers respond to requests.
Yes. I mean, we've referred to this, and indeed we've made points about it in our case. The gist of the evidence, I can take you through all of it, but if you'll forgive me, I'd rather not because of passage of time. But the gist of the evidence was that the bus driver, Mr. Britcliffe, from time to time, how frequently was never identified, would deal with issues like fish and chips and pizzas and so on. You can see that at 421 at the top, or kebabs. You can see how he would deal with that sort of disorderly behaviour on the bus. It's all dealt with at 421. What happens in those circumstances? Well, he would tell them they couldn't board between B and C. And then question, what happens if they don't want to do either of those things? That's bag the food or not get on the bus. If they don't do either, then I would say, I'm sorry, but I can't let you board the bus. And they'll turn around, get off and finish the food. You'd be surprised how many people enjoy their food rather than a bus journey home. And what about it if they're already on the bus, if they've got on and then started eating? And then the answer is given. If somebody did come up and complain, I'd go and ask them to either cease eating or alight the bus. If they refuse to dispose of their food at the next available bus stop, and if they point-blank refuse to eat, you'll see at G, then it would be a case of, unfortunately, your next step would be, I'm unable to move the bus until you cease eating or dispose of the food. So bus drivers, certainly in relation to kebabs and chicken and fish and chips and pizza and other kinds of nastiness, are perfectly prepared, or at least Mr. Britcliffe was, perfectly prepared to simply stop the bus until the matter that was wrong was put right. He gave evidence, though, that it was not something that he would do for a child with a newborn baby, and you see that at 422 at letter F. So he drew a distinction on those grounds. But you also have to bear in mind what he knew about the policy, and I've already told you that as well. So that's actually how the evidence came out. But you can't possibly say that there is no way that bus drivers cannot enforce good conduct on their bus. It's clear, the evidence before the recorder, that Mr. Britcliffe knew exactly how to enforce good conduct on the bus in relation to smoking and kebabs and pizzas and so on, but didn't see that there was a priority issue for wheelchairs and wasn't willing to confront a woman with a small child. But we would submit that that evidence forensically hold the case for the respondent that bus drivers couldn't deal with confrontation. They plainly could and plainly did. The evidence was there, absolutely. And you may think that in the light of that, all the arguments about confrontation were not going to go very far. If you'd been the trial judge and you'd received that evidence, you wouldn't have believed the respondents if they would say that we can't control what happens in our bus. Here was actual evidence of the bus driver doing exactly that that was in front of them. You certainly wouldn't see it as being of the order of difficulty that my friend puts in his case and on which he founds as one of the reasons why this was not a reasonable adjustment to be taken. My Lord, those are the review of the bits of the facts that we submit this court must bear in mind. And I just finish by saying that you will not have seen in the Court of Appeal judgment a detailed review of these. We did try to make some of these points, but the interest in the Court of Appeal was all on the question of whether or not, really all on the question of whether or not a fair balance was struck between wheelchair users and other users in particularly exiguous sets of circumstances. And you've seen our complaint about the way the case went off. The next step in the argument is to take on a whistle-stop tour of the law. Largely, it's not in dispute. It's set out in the respective cases, but it's in order to give the court the opportunity, if it wants it, any member of the court to ask any question about how the law works, but also to highlight just a couple of points as well. If you'll turn to our case, we have set it out very fully. There are two sections to it. First, the introduction of wheelchair spaces on buses, which is Chapter 2, paragraph 55. And then secondly, the duty to make reasonable adjustments, which is Chapter 3 at 65. I'm going to really just ask you to open it and at page 55, where we set out the duty.
Yes.
We highlight the explanatory note, which really is self-evident in the regulations themselves, at paragraph 23. The purpose of the accessibility regulations were stated at the time to be intended to ensure that disabled people can get on and off a regulated public service vehicle in safety and without unreasonable difficulty, and in the case of wheelchair users, can do so whilst remaining in their wheelchairs, intended to ensure that disabled people are carried in these vehicles in safety and reasonable comfort. Now, it's true, and we accept this, that there is no immediately enforceable tort of breach of this duty in the sense of saying that you must admit a wheelchair user to a bus. But we say the clear implication of this is that a bus that has a wheelchair space should be made available to a wheelchair user. And we've developed those points at the foot of page 56, paragraphs 28, 29, and 30. We say it's the obvious logical consequence of those regulations. We've put on the bench a copy of the full version of the PSV regulations.
Yep.
And it's a footnote to the argument, but one which may be of some interest, that not only was there an obligation to have a designated wheelchair space, but there was also an obligation to have designated disabled persons' seats. Similar to those, if you travel on the tube, you'll see the little sign over the seats on the tube, but this is a particular obligation in relation to buses. It's Schedule 2, and that's page 19.
Thank you.
General accessibility requirements for single-deck and double-deck buses, and then you'll see a Regulation 3 over the page. A regulated public service vehicle shall have not less than, it says, 4 seats, and you'll see at sub 3 on the next page, there shall be a sign on or near a priority seat indicating that disabled persons have priority for the use of that seat. So that's why those 2 seats we saw on the bus next door to the wheelchair users' space, why they were there and why they had that notice. We then go to the conduct regulations, and we want, if we may, to just draw your attention to Section 6, Regulation 6 and to Regulation 12.
Yeah.
We dealt with Regulation 12 shortly. There is no doubt that the conduct regulations, which had been introduced in 2006, were amended to introduce a specific provision in relation to wheelchairs.
Can you help me with the relationship between the different regulations? The ones you've just taken us to seem to be about the physical layout.
They are indeed,
and equipment.
Yep.
On buses.
I beg your pardon. Yes, my lord.
So presumably one finds somewhere else. I assume one finds somewhere else legislation governing enabling people to actually make use of this equipment.
The short answer is, my lord, you don't, except when you get to the duty to make reasonable adjustments. What you do get, and this is me hypothesizing, but the regulations themselves were made under the Disability Discrimination Act. We've made that point. That's where the source power came. When the Act was first passed in 1995, it did not reach into transport because of the cost implications of requiring huge amounts of change. There's much parliamentary discussion and departmental discussion about how this could be addressed and what the cost implications were. And over time, and of course there was also discussion about this in Europe because there's a common transport policy which addressed this issue. And the PSV regulations are concerned with essentially with the construction of spaces. And of course there were cost implications for that, and there had to be standardization so that wheelchairs were a standard size, or at least the space was for a standard size, and then wheelchairs could be manufactured to fit it accordingly. So that's how that worked. What then happened was that, and this is in answer to my lord's point, is that there was a duty enforceable as a criminal act, in criminal law, imposed on drivers and conductors in relation to access to that space. And that's in Regulation 12.2 of the conduct regulations. Mm-hmm. I'm going to open the conduct regulations for you in a moment, but it's quite convenient to see it in my case. It's at page 58.
Thank you.
MS 58.
The conduct regulations are made under completely different
They
legislation.
are indeed, my lady. Yeah. But what happened was that, picking up on my Lord Reed's point, how do you get into the wheelchair space? The answer is that a specific criminal duty was imposed on conductors and drivers.
Yes.
And it's set out at 37 and 38.
Yeah.
It said, if there's an unoccupied wheelchair space on the vehicle, a driver and a conductor, and the definition is interlinked about wheelchair space, shall allow a wheelchair user to board if the wheelchair is of the type or size that can be correctly and safely located in the wheelchair space, and in so doing, neither the maximum seating nor standing capacity of the vehicle will be exceeded. Regulation 12.3 defined a wheelchair space as being occupied if there was a wheelchair user in that space, or B, passengers or their effects are in that space, and they or their effects cannot readily and reasonably vacate it by moving to another part of the vehicle. Now, that begs a whole number of questions, because the amendment to the conduct regulations made no provision as to when effects could when the space could be readily and reasonably vacated by moving the passengers or the effects to another part of the vehicle. It's relatively easy to deal with passengers, because obviously if you move passengers, there's a maximum quantity. But on the question of effects, it depends on the terms of carriage. If you get on a bus with something that it's actually unreasonable to carry on a bus, then the driver or conductor is going to have to say, you should move it. The terms of carriage become really important in the operation of that provision. And so, in short, bus companies are able to make, through proper definition and proper rulemaking and proper setting of priorities and training, are able to set the confines of Regulation 12.3 sub B. That provision was introduced at a time when the duty to make reasonable adjustments did not exist in relation to transport. And there's no evidence that it anticipated it in any way at all. It simply took up the question that everyone was asking, Lord Reid articulated, how do you get access to that space, and imposed a duty, as I say, punishable as a misdemeanour, as a crime in the magistrate's court, if there is a breach of Regulation 12.2. Now, I have to come on a little bit later on to the way in which that has been dealt with in guidance. It may be convenient to deal with that because a point is taken about that.
Can I just,
I'm so sorry.
Can I just ask you, just reading the legislation, say, for example, the passenger had a suitcase, a large suitcase in the space, and you apply the legislation, their effects are in that space, their effects cannot readily and reasonably be moved to another part of the vehicle. I mean, to say that's a state of the facts. Then, well, so far as Regulation 12.3 is concerned, the wheelchair space is occupied, is it not?
My Lord, the wheelchair space could be occupied if that is a suitcase which can properly be carried on the bus within the terms and conditions. But
well, if it's actually there, I mean, isn't 12.3 satisfied? I'm wondering if 12.3 is the end of the story, or if there's something else we need.
The short
Not the
answer,
end of the story.
it is the end of the story as far as criminal responsibility of drivers and conductors. But it is not the end of the story as far as the duty to make reasonable adjustments is concerned. And you will already have seen...
My Lord's example, B would be satisfied. With 12B. Maybe later on.
Exactly so.
How it's dealt with in the reasonable adjustments regulations is something different. But tested as at this moment,
my Lord, I accept that proposition. I do absolutely accept it.
Why are we looking at this then? If you don't rely on this, you rely on reasonable adjustment.
I don't rely on it, but it's pleaded against me, my Lord.
But this is, you say, is simply creating a criminal offence, and it's a separate issue from the. Is that right?
If my Lordship says get on with it.
No. Well, it's a matter. It's a matter for you. You've got a time limit. But all I'm saying is, as I understand, your argument is that this is irrelevant. We're concerned here with making reasonable adjustments.
Absolutely so.
Yes, I understand.
But you could also say that the reasonable adjustments that you could make would actually enable 12.3 to work in a sensible way. Because, for example, you could have terms and conditions which say you mustn't block the wheelchair space.
Well, pretty close to what Stagecoach says, essentially.
Yes, I understand that, but that's not. I slightly feel that my answer to that is so what? Because your point is on these proceedings, you rely on reasonable
My
adjustment.
Lord is absolutely right. I have a better point.
Right.
And not only do I have a better point in the way exactly that it's put, but I also draw comfort from Ackerman Lister, because we've pointed out in Ackerman Lister, this court pointed out that you have to deal with the duty to make reasonable adjustments on its face at the time that it's enacted. And it's a response to the fact this is a progressive development of rights. So my Lord has my points on that, and I don't need to waste more time on it. It's dealt with in my case.
Thank you.
And I leave it there, and my friend can deal with it, but if necessary, I shall deal with it in response. So that's 12. That's Regulation 12. What we do rely on, and which is important, is Regulation 6, and that is in Authorities Bundle. It's tab 22, and that is
23 is the conduct regulation.
23. I'm grateful to my lady. Yes, 23. Can I just pick up on one short point about this too? When you look at tab 23, please note that there is a Scottish and an English and Welsh version of the regulations, and so they're rather repetitive, but there's no significant difference between them. But what we rely on here is Regulation 6. And we say Regulation 6 is a really powerful tool for bus companies to ensure that they get what they want on the bus. And I'm just going to take you on a whistle-stop tour through that. It's 1613 in the English version.
Yep. Thank you.
No passenger on a vehicle shall, and I won't read all to it, but the highlighted ones are, B, put at risk or unreasonably impede or cause discomfort to any person travelling on or entering or leaving the vehicle, etc. K, remain on the vehicle when directed to leave by the driver, inspector or conductor on the following grounds. Well, exceed capacity, which we don't need here, but 2, that he's been causing a nuisance, or 3, that his condition is such as would be likely to cause offence to a reasonable passenger, or that the condition of his clothing is such, and we don't need to read that. And then over the page at 2, subject to para 3, a passenger on a vehicle who has with him any article or substance mentioned in 4, if directed by the driver, and 4, we jump forward to it, it's my Lord's example, a bulky or cumbersome article, or an article likely to cause annoyance to any person on the vehicle. And then going back to 2, if directed by the driver, inspector or conductor, put it in a particular place on the vehicle, and if requested to remove it from the vehicle by the driver, inspector or conductor, shall remove it. So it goes considerably further than Regulation 12. The suitcase could be ordered off the bus under Regulation 6 in suitable circumstances. Now we say those are really powerful powers. Nobody has suggested that they don't work or that they're no use. An argument has been put against us that they were not amended after this case was heard in the county court. I'm going to just simply make a very short point about that. That point's thoroughly bad. There was a consultation under the red tape challenge suggesting that these regulations might become less burdensome, not more burdensome. So there was no possibility under the consultation to consider enlarging the scope of these regulations. But be that as it may, we say these regulations are really powerful and are capable of being deployed sensibly in circumstances to give effect to the policy for which we argue. I'm going to, if I may, just take you forward to 8 and then show you the case that's on the bench. If you go forward to 8, which is 1620, There's a rather old-fashioned, but no doubt effective mechanism for making these work. Any passenger on a vehicle who is reasonably suspected of contravening any provision of these regulations shall give his name and address to the driver inspector or conductor on demand. And any passenger who contravenes any may be removed from the vehicle by the driver inspector or conductor, or, on request of the driver, by a police constable. So you say to the passenger, I need your name and address, you're being a nuisance, you must go. If you don't go, you can radio through to control and a police officer can come, or somebody from depot can come to remove them. That's how it works. Very shortly, you'll see on the bench, we wondered whether there might be any question about what nuisance meant. The judgment in Remington and Goldstein, which is on the bench, and you'll see that in the first holding on the first page, common law offence of causing a public nuisance as currently interpreted and applied was committed when a person did an act not warranted by law or omitted to discharge a legal duty, and the effect of the act or omission was to endanger the life, health, property or comfort of the public, or to obstruct the public in the exercise of their rights common to everyone, etc. So that's the general approach. And we would say that that means that Regulation 6 was entirely apt to work in circumstances such as these. Whether you needed to go as far as that, as saying there's a nuisance, there are powers of direction which are set out in Regulation 6, which are enforceable. So those are our submissions on enforceability. There is a real mechanism that was available, and the Court of Appeal simply didn't engage with it and didn't recognise the force that it had. In practice, although this was all shown to the recorder, he thought it pretty rare that it would need to get to that stage if the terms and conditions were changed. We'll see that in his judgment, of course.
I mean, the problem with
My Lord.
the difficulty with relying on 6.2 is that it has to be, Regulation 6 has to be read along with Regulation 12. They're in the same, they're part and parcel of the same regulations, and 12 is concerned specifically with wheelchairs.
Well, my Lord, Regulation 12 doesn't give rights to passengers. It imposes criminal duties, criminal responsibility on conductors and inspectors. And so that's the first answer to my Lord's point. The second is that Regulation 6.2 gives power of direction to the conductor and driver and inspector. That's what this is all about. It's an enforceable power of direction. And so it's up to the bus company to work out the context within which that power of direction has to be used. And that's, of course, the point that we've already made about changing terms and conditions and so on, and the possibility for doing that. Yeah. And for recognising real priority for the wheelchair users to have access to the designated wheelchair space. All of that, in any event, my Lord, and this is my Lord Newberger's point, has to be read and applied and given effect in the context of the duty to make reasonable adjustments. And we say it's perfectly reasonable. Nobody could argue that it's...
This is all part of the reasonable adjustments argument. I mean, do you say that you'd be entitled to succeed even if there were no provision in relation to reasonable adjustments?
Well, my Lord, what we would say is that if there was no duty to make reasonable adjustments, we would say that Stagecoach, for instance, prior to the introduction of the duty to make reasonable adjustments, could rely on Regulation 6 to enforce its terms and conditions.
No, the question is, would your claim here succeed without the reasonable adjustments provision?
Well, our case is entirely founded on the reasonable adjustments.
Exactly, right, precisely.
That's all.
Your case would not succeed without that duty.
No.
This case. Equally, however, your case could succeed without any regulations like this at all.
Both points, I accept.
There are loads and loads of equality duties which are enforced via the sort of proceedings that we're conducted in now, which aren't backed up with all of this stuff.
Well, my lady, I'm grateful for you making that point. In short, what we say is the argument that our case is unenforceable founders in practice because of other examples such as that, and it founders because there is actually specific legitimate power, legal power that is given under Regulation 6. It's simply not arguable that it couldn't be enforced. I accept there may be, from occasions when it's enforced, there may be some confrontation. But as we've made very clear in our case, the adjustments we suggest are designed to avoid confrontation, except in the most limited of circumstances. So that's that duty. Now, I really don't have a lot of time, bearing in mind I've only got half an hour, to take you through all the reasonable adjustment duties, which are in Chapter 3, how they develop. I want to make really 2 points beyond that which is said perhaps I think it's 3 points, I'm sorry, that is said in great detail. Perhaps there are 3 points of emphasis. The first is that the Equality Act itself recognised that the duty to make reasonable adjustments on public service vehicles may involve affecting what happens on the vehicle when somebody is travelling in it. In short, you don't get vested rights which defeat a claim for reasonable adjustments simply by getting onto a public service vehicle. If you'll turn to our case, page 71 to 72, you'll see this is where we deal with Schedule 2.
Yeah.
And if you'll go to paragraph 3, special provision about transport, this paragraph applies where A is concerned with the provision of a service which involves transporting people by land, air or water. 2, it's never reasonable for A to have to take a step which would, D, affect what happens in the vehicle while someone is travelling in it. And then if you go to E, or 3E, but for the purposes of complying with the first or third requirement, A may not rely on subparagraph D if the vehicle concerned is a public service vehicle. So Parliament contemplated that reasonable adjustments may involve affecting what happens in the vehicle while somebody is travelling in it. And you can see the obvious good sense of that. In short, shuffling people around on a bus or moving them may be part of what is necessary for the duty to make reasonable adjustments. If your lordships and my lady will go to page 74 in our case, I'm afraid there's a typographic error in paragraph 79. We've cited the right text, but referred to paragraph 2 of Schedule 2. It should be paragraph 3D.
Thank you.
So that's point one. The second point that I wanted to draw to your attention is not in our case, but, and indeed it's not a current issue before this court, although it was beforehand. It's the question of the comparison in the reasonable adjustment context. There was an argument at first instance suggesting that the comparison was limited to other disabled persons or to other people with mobility difficulties. And it's right to say this because of the importance of this case, that if you'll turn to the Equality Act itself, the ordinary rules on comparability do not apply in the context of the reasonable adjustment duty. So if you'll turn in Authorities Bundle 2, at tab 20, page 1503, if you'll simply note that the section 20, duty to make reasonable adjustments, and then if you'll go to 1507, the standard comparison clause for equality cases, on a comparison of cases for the purposes of, and you'll see it says 13, 14, or 19, but not 20, there must be no material difference between the circumstances relating to each case. And the purpose for that,
I'm sorry, could you just give me the number of the...
Page 1507, section 23, sub 1.
Thank you.
The reason for that is because the Act recognises, as this House has said in Archibald, as we've cited in our case, that disabled people are in a different position in terms of comparison compared with men against women, black people against white people, gays against straights, and so on. If the comparison is conducted on that basis, there is no prospect of substantial equality, only formal equality for disabled people. That's why that provision is put in that way. The third point that I want to draw to your attention anticipates an argument which you probably won't have to deal with, but it's important, and we need to just mention it very, very shortly. And that is concerned with the duty to make adjustments in section 20. If you will look, please, at section 20, you will see that the duty arises, or has its first requirement in 3, and sorry, I'm dealing with the wrong provision. Section 21, which is paragraph 73. You'll see in section 21 on paragraph 73 on page 70, the failure to comply with the duty, failure to comply with the first, second, or third requirement is a failure to comply with the duty to make reasonable adjustments. A discriminates against a disabled person if A fails to comply with that duty in relation to that person. In relation to that person does not mean necessarily that that person has suffered a disadvantage. The disadvantage provision is dealt with in section 29 in the detriment provision, which makes the discrimination unlawful. I make that point simply because the phrase "in relation to that person" echoes the way in which the duty is made anticipatory in the previous provisions. And there are cases, for instance, where it's necessary under the public functions part of the Equality Act to have to bring cases before actual detriment is suffered, but where a reasonable adjustment should be made. There's a hint of a suggestion in my friend's case that he takes a more restrictive view about that. He and I were both in a case called M&M, which explored that, and that's really just putting down a quick marker about our interpretation of it. So those are the points that we make on the disability discrimination provisions in the Equality Act. Now I must take you as quickly as I can in the time permitted to the judgment and to the, I probably won't take you at any great length through the Court of Appeal because our submissions are in our case, but I do want to show you the judgment of the Recorder as to how he dealt with these issues.
Yes, you'll bear in mind that we have read it.
Of course. These are points of emphasis, my Lord.
I understand.
They will take no great time.
Thank you.
Page 305 is where the judgment starts. And my Lord has already made various comments about the evidence. The schema of the questions that are to be asked were agreed between the parties, the heading. They went through them, the comparison question, and so on. And comparisons dealt with 11, and that moved on to the next key question, which is the debate before you. Are there reasonable steps that could have be taken to avoid the substantial disadvantage, and if so, has the defendant failed to take such steps? And you will then see the items that were put forward by Miss Castley catalogued at 38. If you have a paper copy, it will be convenient to put a pencil line through Little Roman 2, Little Roman 13 and Little Roman 14, which were not pursued. And what remains are these: insisting the pushchair was folded, giving wheelchairs users priority, making clear to other passengers that the space is for wheelchair users, they'll be expected to vacate it, and so on, and having a clear policy to warn, ask and train bus drivers to persuade the passenger to move, requiring bus drivers to ask passengers to fold their buggies, instructing training drivers how best to accommodate, offer other passengers onward tickets, refuse access to buggies, prams and pushchairs which cannot be folded, offer taxis to either disabled passenger or passengers with buggies who leave the bus in order to vacate the disabled bay, refuse to continue the bus journey until the passenger moves from the wheelchair space, insist the passenger leaves the bus. And it's that last one, 12, which is last in order of sequence because it's last in order of need. The whole purpose of the submission was to say, create a culture in which people know what is the order of preference. Judge dealt with it in 15, and 15 can be read in a number of different ways, but we think its meaning is entirely clear. It became apparent as the hearing proceeded that the real adjustment alleged on behalf of the claimant, and which the adjustments referred to above were all part of, was that the practice of first come, first served, or even that the wheelchair user should have priority over any other passengers with a buggy or not, for the use of the space, as set out above, only following a request, did not give sufficient protection to the wheelchair user, allowing as it did the non-wheelchair user to decide whether to agree to move. And that is what the recorder took objection to. What was required was a clear practice or policy which not only paid lip service, but actually enforced such priority. And we say enforced means every bit of the culture. It means from the moment you get onto the bus, saying you've got to make this space available, you can't have unfolded buggies and so on, unfoldable, through to, if necessary, getting off at the end. All of that is part of the enforcement adjustment. To that extent, the most comprehensive adjustment was that it should be made clear to other passengers that the wheelchair space is for wheelchair users and that they will be required to vacate the space if needed. Once such a practice was put into effect, with a proper system, notices, warnings, advertising, the culture will have changed. No non-disabled passenger who wishes to occupy the space would be under any illusion that if there's competition, they would have to vacate the space by folding a buggy and sitting elsewhere, or by leaving the bus and taking the next bus available.
Would the notice on the window have been satisfactory if the word please had been omitted?
Well, it would have been better, my lord, by a considerable extent. Our submission is that there was still this conflict on the bus between the two notices, because if you recall, the first notice I pointed out to you suggested that that was a buggy space which could be occupied by two buggies. So that it's not enough to simply take the please out, but it would have been better, and all the other things that we've said would have reinforced it as well.
So if there'd been no notice at all about buggies and the please had been omitted, the notices would have been satisfactory.
Well, my lord, I don't suggest that that is the only way that it should have been dealt with, because it's also important that the policy is changed as well. The policy, as set out by the bus driver, which I've referred to, was you request, but you cannot require. And our submission is that the policy should have been required. Now, I make it absolutely clear, there's not a word in here about emergency situations or particularly difficult competing rights, because there was no argument in front of the recorder that this had to be considered in some other moderated way to take account of accidents, for instance, or whatever it may be. The extent to which the adoption of such a policy would also require an insistence, should be asked their voters, should be trained to enable them to better persuade passengers. The most effective adjustment would remove the disadvantage. It was argued on behalf of the defendant it wasn't reasonable to expect the defendant to take such a step. The thrust is that such a policy would be likely to cause confrontation and difficulties between the wheelchair user and the non-disabled person with a buggy wishing to use the wheelchair space and the driver. That was the argument. That was the argument. It is said that there's no sanction that could be taken if the non-disabled passenger refused to move. This would be disproportionate action, lead to substantial inconvenience on other passengers, disruption to services, and so on. And then he properly directed himself by reference to the code, which you've already got. He properly took into account Mr. Hodgson's evidence about conflicts and so on. And Mr. Hodgson relied on Section 12, Regulation 12, but he concluded that that was not relevant. And he deals with the response argument at 18. Defendant's approach overstates, exaggerates the extent of the difficulty in changing culture. Having a policy in place which lacks teeth to enforce the policy is no effective policy. Just not right to say there's no power in the defendant to require a non-disabled passenger with a buggy refuses the space to do so. All points which I've made to you and which you can see there. And as to the defendant's reliance upon, and that's Regulation 12 that's being referred to in the bottom part of paragraph 18, it's a specific provision requiring a driver to permit a wheelchair user to board, meant that there's an enormous difference between imposing criminal sanction and so on. He then dealt with Birtwhistle's evidence, and he picks up the point I've said, if we had a power under law, we would use it. And then at 20, I was told by Miss Castley, it was not challenged by the defendant, that there were a number of other bus companies, for example, Lothian and London Transport, and that's where we say the error is it should have been Stagecoach. London Transport was referred to, but not in this way. I can show you the submissions, if necessary. And then his conclusion, 21. In my judgment, there's little doubt that had the practice suggested by the claimant been in force, he would have been able to travel. The practice suggested by the claimant, namely the system of priority given to wheelchair users, should be enforced as a matter not of request to any non-disabled user of the wheelchair space, but of requirement. It could be incorporated into conditions of carriage, plainly could, I've seen that, evidence of that, so that any non-disabled wheelchair user, passenger, could be obliged to leave the space if requested to do so, because the wheelchair user needed to use it. Now, it's a small point. It's not, and we don't read the judgment as the judge saying that in every case, a non-wheelchair using passenger should be obliged to leave the wheelchair space. The policy, the amendment was that they could be obliged to do that. And there was, as I say, no discussion of terrible conflicts of the kind that seemed so important to the Court of Appeal, and which my friend has relied upon in his submissions. Just as there are conditions of carriage which forbid smoking, nuisance, other antisocial behaviour, they could be enforced with similar consequences. And if there had been advertisements and so on, it would have been unlikely to cause disruption. Bluntly, we say that once the evidence is considered, the law is considered, the issues that actually he was confronted with are considered. The only possible way that that can be attacked is by saying his conclusion was perverse. And that's not a task for this court, and it's not how it was argued in the Court of Appeal. And actually, it's impossible. It wasn't perverse. The policy that they adopted of request, not require, no priority for wheelchair users, of having, in fact, created an expectation that buggies could use this space by their notices, all those things inevitably led to the judgment that this recorder gave. I want to just show you shortly a passage in the submissions of Mr. Hodgson dealing with the injunction point and how that was left over as well. We have the transcript, of his submissions. And if I can just take you to that, it's at page 456.
Yep.
Mr. Hodgson, then counsel for the transport company, picks up his concluding points at page 456. I don't read all the passage between E and F where he's discussing the awards of damages. But then at G, is the idea that the award of damages is high enough to make the defendant think twice about not changing their approach, if I came to that conclusion? It would mean in real terms that if an award of damages is made, then if the defendant doesn't change its policies as identified, it is going to be open to continued challenge and awards effectively. The real point is the extent to which, having heard the evidence, and Your Honour will have heard the evidence in relation to the changes, the new buses, so there was some evidence about new buses, and as I understand it, some of the new buses had buggy spaces as well as wheelchair spaces. And then Mr. Hodgson, yes, the extent to which injunctive relief is really appropriate in this case. Now, if Your Honour feels there's an issue in relation to injunctive relief, again, my learned friend and I said that it's probably a fairly lengthy and complex argument, not one we could probably address today fully, but I will leave that as a matter for the court. So positively encouraging the court to leave over the detail of any mandatory order that had to be made. And the judge picked that up in his judgment. You'll have seen it in the last paragraph of his judgment, and held it over. So it's certainly open to First Bus to come along and say, well, we've got other competing duties of reasonable adjustment to people with Zimmer frames or walking frames or other people of some other kind that we've got duties to, and the injunction will have to be crafted accordingly. The key point in the argument was not about that. It was about the fact that the policy was request, not require, and did not give priority of any kind at all to wheelchair users. And so we say practical justice. The actual policy that's put forward was tested. It was tested, it was compared with policies by other bus companies. It was considered under a rubric of questions which it's accepted now and then were the right questions that had to be asked. The attack now is that the adjustment to the policy to make it enforceable in favour of Mr. Paulley and other wheelchair users was not legitimate because it was not reasonable, because it couldn't be enforced, and because it didn't balance out other considerations. And we say that on any fair reading of the process that took place in this case, that's simply unfair attacks that should not be permitted to be made. My Lords, that leaves me 7 minutes to deal with the judgment of the Court of Appeal, and it's not enough to make detailed submissions, but I'm not worried about that. Our case sets out our points about this fully. We've actually gone through it bit by bit and all the points that are made. The only thing that I can conclude with, and really I have to say, when we read this part of the judgment, we wondered what had been going on, is when Lady Justice Arden, in her part of the judgment, actually catalogued as adjustments that should have taken place at least 3, if not 4, of the adjustments that Miss Castley had argued for. Lady Justice Arden, though, took the view that going further and saying that this was enforceable was a step too far, and that it would be up to Parliament to remedy that in due course. Well, if that's right, so be it. But if it is right, it means that the reasonable adjustment duty in the Equality Act is a blown balloon. It doesn't have the effect for which disabled people think it does. It will not lead to the kinds of changes that are needed to give disabled people the substantive equality that it's intended that they should have. I've stopped 5 minutes early, and I'm sure that will be welcome. My Lord,
This is a reference to paragraph 80 is of
yes,
Justice Arden's.
we deal with that
Yes.
fully in our submissions at page 98 in the case.
Follow that.
Paragraph 173. Paragraph 80 is where she says it. If your lordship...
Well, the answer is yes, thank you.
You see it all in that. And we've catalogued what we have said. Would you allow me just to turn my back on you for a moment? Is there anything else? I'm allowed to sit down.
Thank you very much indeed. Thank you, Mr. Allen. Ms. Casserly. Mr. Chamberlain.
My Lords, my Lady, I'd like to make submissions under 5 heads. First, a summary of the issues in the appeal and of our case. Second, the legal framework of the Equality Act. Third, the significance in our submission of the regulatory framework to the reasonableness of the adjustment identified. Fourth, the practical difficulties flowing from the recorder's judgment. And fifth, the alternative adjustments relied upon by the appellant here, but not before the Court of Appeal. Can I turn to the first of the 5 heads? This is an appeal from the Court of Appeal, and the question before them was whether the recorder was wrong to find FirstGroup liable to the appellant for the statutory tort of discrimination. The tort involved a breach of the duty to make reasonable adjustments in relation to the appellant. The duty arose because, in terms of section 20, subsection 3 of the Equality Act, I don't ask you to turn up now, a provision criterion or practice of FirstGroups, namely its practice of according access on a first-come, first-served basis, puts disabled people at a more than minor or trivial disadvantage. That's the definition of substantial in section 212 of the Act.
Right.
Compared, that is, to non-disabled people.
We were just amused because we've just been discussing what substantial means in a completely different context.
And the comparison with trivial was a specific issue.
Well, here we have the benefit of a specific statutory definition.
Thank you.
In those circumstances, FirstGroup had to take such steps as it was reasonable for it to have to take to avoid this disadvantage. Now, as a starting point, FirstGroup already takes steps to meet this disadvantage. And I want just to show you some of the steps. First, and obviously, it has signs, which you've seen in Appendix 2, internal page 623, MS page 900.
Yes.
Which say, please give us this space if needed for a wheelchair user. Now, I'm going to come to this in a moment, but because of the question asked by my Lord Sumption just now,
Yes.
Would things be different if the word please had been omitted? The words used are prescribed words, and they are set out in the accessibility regulations, and I'll come to show you those. And the requirement, which is a statutory requirement, is to use those precise words or words of equivalent meaning.
Right.
Its drivers, secondly, are instructed to request any passenger in the wheelchair space to vacate it if needed by a wheelchair user. And the current policy you have in Appendix 2, internal page 392, at page 669.
Thank you.
Now, there is no evidence.
That's the current policy.
That's the policy that was in fact before the recorder, and I'll come to that in a
I
moment.
see, because Mr. Allen suggested it wasn't.
It's the policy that was current at the time of the trial,
But not at the time of the event.
but not at the time of the incident.
I misunderstood. Thank you.
But we'll come on to see that the recorder thought that there was no difference of substance between the two policies,
That's
because
right.
he thought that what mattered was what the driver actually does, not whether he uses the word priority to describe the policy, but what he's actually instructed to do. And what he's instructed to do is to make a request. But I'll just show you, if I may, the current policy, just so that you have it.
Current meaning current.
Current at the time of the trial and to this day.
Right.
So this is at MS 669.
Yes.
Internal page number is Appendix 2, page 392. Wheelchair users have priority use of the wheelchair space.
It's the longest paragraph.
Sorry, can
Yes.
you give me the internal numbering? Sorry.
I'm sorry, the internal page is 392. Wheelchair users have priority use of the wheelchair space if this is occupied with a buggy, standing passengers or otherwise full, and there is space elsewhere on the vehicle. The driver will ask that it is made free for a wheelchair user. Please note that the driver has no power to compel passengers to move in this way and is reliant upon the goodwill of passengers concerned. Unfortunately, if a fellow passenger refuses to move, you will need to wait for the next bus. So that's the policy. Now, one question that was put to my learned friend was whether there was evidence put by my Lord Reid, whether there was evidence of a pervasive problem with the use of this policy. Now, the evidence on that from the appellant himself is in Appendix 1, MS 409 to 410.
Thank you.
He was asked at 409, letter G. Now, it's right, is it not, that up until this particular incident, you'd had no problem gaining access to the bus, had you? And then he said, I'd had difficulties or there'd been issues previously where I'd had difficulties or been unable to use the bus for other reasons, but not specifically in relation to the wheelchair space. And the answer was no, not to my recollection. And then it continues over the page. He mentions an incident where someone was prepared to move but had great difficulty in doing so, and in that case he offered himself to get off and catch the next bus. But apart from that, he says, I can't recall any other occasion when I've been unable to get on because a pram user or a pushchair user has refused to vacate the space, despite the fact that he was a regular user of buses. And that was consistent with FirstGroup's own evidence, which you have seen. I'll just give you the references because you've already seen it. But that's at MS 428 and 437, that in the majority of cases, yes, passengers do comply either with the notice or with a reasonable request from the driver. Now, exactly the same conclusion was reached on different evidence by His Honour Judge Bowers, sitting with an assessor, hearing evidence in a sample of 10 linked cases.
Was this the
case
one that
of
also
Black.
was meant to be heard at the same time in the Court of
Exactly.
Appeal, but settled, yeah.
And can I just show you what he said about this? It's significant because, as Your Lordship has said, the reason why leave to appeal was granted to the Court of Appeal in
Lord
this
Justice
case
Lewison explains, yes.
is because there were two conflicting first instance judgments. And the judgment in Black was a judgment which was based on evidence culled from 10 linked cases, considerably higher volume of evidence, as it were, than in this case. What you have Black in Authorities Bundle 1, tab 4, MS 1008.
Thank you.
And he records at paragraph 29 of his judgment, MS 1015, evidence given by two drivers who were tendered in those cases. One of them had some experience of pram users who were unreasonable or unfair, but said that it was very rare that he could not sort out the problem, and that most passengers cooperated willingly. The other had never had any passenger refuse or cooperate, apart from the incident involving the complainant.
So sorry, which paragraph was that?
I'm sorry, 29, and it's on MS 1015.
Thank you.
In his experience, in many cases, passengers cooperated without the need to be asked, and it was only sometimes he had to ask them to fold the pushchair or move. Now, my lords, my lady, we say it should not be a surprise if, in the vast majority of cases, passengers respond positively to a polite request to assist a disabled person.
We had the odd bad apple comment from the driver in this case.
Yes, of course, that's not to say that there won't be a bad apple, as you've seen from the evidence, but the question that was put during the course of my learned friend's submissions was, well, how pervasive is this problem? And obviously that was an issue which is relevant to reasonableness when we come to see the adjustment identified. We have also, and you've seen it, so I just give you the reference, from FirstGroup's perspective, it's evidence that communicating with its passengers in terms of polite request rather than peremptory instruction is more likely to achieve compliance. In other words, in terms of the effectiveness of what they do, their review revealed, Mr. Allen is right to say that the review was not specifically directed to the issue of wheelchair users. It was a general review of how they communicate with their customers.
Does the evidence actually go?
Where do we see that? Because I have the same difficulty as Lord Sumption. It's what Lord Justice Lewison says in paragraph 51.
It's at 436. It's MS 436.
I mean, that seems to say it's generally a good idea.
Yes,
to be
that's
friendly.
right.
It improves relations with customers.
He
doesn't
goes on
actually go so far as to say that there was any experience suggesting that it was more effective in getting them to comply.
yes, that's exactly how I
Well, he says the view was taken at that time that it would be a much better policy to adopt wording on notices which was more pleasant, more engaging, more customer friendly.
yes.
And he goes on to say that your lordship is right to say that he doesn't talk in terms specifically of effectiveness there.
No.
But when
Not
he
least because there was no experience of peremptory instruction.
well, but when he does use the word better, and it
Well, I
doesn't
mean, that's
it doesn't take much.
a judgment, but it's not evidence-based, is it?
Well,
There was no cross-examination about this.
I
That's the problem.
can't go further than what's in the
It's
evidence.
simply
There was a
opinion
review.
expressed.
The review.
Well,
There
it's
was.
more than that, isn't it? Because they undertook a review, but we don't know what the review
No, we
involved.
don't.
That's the trouble.
We don't have that in evidence. We
No.
don't have that in
I mean,
evidence.
you are, I suppose, in a position to say that the evidence seems to be that politeness does actually work
Yes,
in the great majority of cases.
indeed. Indeed. And we do make the submission based on, I accept, or limited to the evidential base that you see there, that politeness is likely to be effective.
And then the evidence goes on. He's cross-examined about whether this. He's very imprecise about what the review involved. To be fair, he wasn't cross-examined about it.
Yes.
He's very imprecise about when it happened, but it clearly was before the Equality Act duties came into force. And they didn't then reconsider, because Mr. Allen took us to that too.
It's absolutely right to say that this was not a review that was specifically undertaken in view of the position of wheelchair users or in relation to Equality Act duties.
And also, it wasn't reconsidered in relation to Equality Act duties at all.
No, it was not.
No.
That's correct. Now, we say the next point to look at is what the recorder said in his judgment at paragraph 5 about the priority policy, because Mr. Allen has relied in his submissions on what the driver said in cross-examination about the priority policy. So if we just look at paragraph 5, of the recorder's judgment, which is MS 306, one can see that the driver did not understand the policy as one that gave priority to wheelchairs, but the recorder makes clear at paragraph 6 that however you describe the policy, the driver had correctly understood and given effect to its essence, which was that a person occupying the wheelchair space would be requested to move, but if the request was refused, not required to do so. That's the essence of the policy. Well, I describe it in that way because that's what the driver actually had to do, rather than the description that he gave to the policy. Now, the question for the recorder was whether there was a further adjustment that it would be reasonable for FirstGroup to have to make. As a matter of logic and law, a finding that the duty to make reasonable adjustments had been breached required a finding not just that what FirstGroup currently did was insufficient, but also that there were particular further steps, a particular further adjustment that it was reasonable for FirstGroup to have to take. And the adjustment that we're talking about is an adjustment to its policies, criteria, or practices. The adjustment he identified can be seen from the first part of paragraph 15 of his judgment, which you have at MS 316, and also from paragraph 21. It's the sentence in the middle of page 316, beginning what was required. What was required was a clear practice/policy which not only paid lip service to the giving of priority to the wheelchair user, but actually enforced such priority. And one sees the word enforced again at 21. If one just goes forward to 21, which is on page 322, the practice suggested by the claimant, right at the top of 322, namely that the system of priority given to the wheelchair users should be enforced as a matter not of request to any non-disabled user of the wheelchair space, but of requirement, is, to my mind, a reasonable one. And at 22, we can see that the recorder addressed the question whether the failure to make the adjustment he identified had led to a detriment to the appellant personally within the meaning of section 29(2)(c) of the Act. And the answer was yes, because he had on that occasion had to take the next bus, which delayed him by 16 minutes. And the remedy, as can be seen from 24, was an award of damages, £5,500. Now, that latter finding was, of course, also dependent on the prior identification of the adjustment that FirstGroup should have made, and on a conclusion, which you see set out in the second sentence of paragraph 21, that had FirstGroup made that adjustment, the appellant would not have been delayed. Now, at paragraph 25, you can see that the recorder adjourned the application for an injunction so as to leave it to FirstGroup in the first instance to decide how to adapt its practices in the light of the judgment. But it's important in our respectful submission to understand what that meant. The recorder had by that time already found FirstGroup liable for a statutory tort, consisting in a failure to adopt a particular identified adjustment. There was no question but that it would have to adapt its practices so as to make that adjustment. In other words, it would have to adopt a policy of requiring, any non-wheelchair user to move, and it would have to enforce that policy by one means or another. The issue, as comes out very clearly from the passage in submissions that you were taken to just a moment ago by Mr. Allen, was simply whether an injunction was actually going to be required. In other words, you assume, once a judgment has been given of this kind, that a defendant such as FirstGroup will bring its practices into line with what the court has said its legal duty requires, without needing any coercive order by the court. There was no question of FirstGroup being able to argue before the court on the injunction application that actually it didn't need to make the injunction, didn't need to make the adjustments that had been identified, and failure to make which adjustments constituted the tort.
I wonder if this is a point of significance. The matter would have gone back for a further hearing if the appellant wasn't content with the change of practice which had been made, and then inevitably the judge would have had to consider what precise form the injunction should take, and it would have been open, would it not? It would hypothetically be open to the company in those circumstances to say, you shouldn't craft it in this form because it would have this, that, and the other consequence.
Certainly, it would have been open to the company to make submissions as to the precise form of the injunction. What they could not have done is made submissions, which the effect of which was that they hadn't committed the tort in the first place.
But contingencies such as, well, what happens if a person occupying the space is being rushed to hospital or has a Zimmer frame, would be the sort of points which could have been raised.
Well, not necessarily. Not necessarily. It depends how you understand the terms of the duty to make the adjustment.
These points, as we understand it, weren't raised before the recorder. It seems to me unlikely that the recorder wouldn't have been prepared to consider them in fine-tuning of the injunction. But does it really help in resolving the issues with which we are now concerned?
Well, it's important to this extent. I mean, I certainly accept that there is a clear issue before this court, and it is in everyone's interests that the issue is determined one way or another by this court. That's one of the reasons why my learned friend's arguments to the effect, directed to saying that we can't look at some of the points that the Court of Appeal looked at would leave us in a very undesirable position, because it would leave us in a position where there was a first instance judgment upheld, but there was another first instance judgment on different evidence in black, which hadn't been appealed, and there would be no judgment of this court indicating which of the two approaches was to be preferred.
I can well understand, Mr. Allen's point that relying on arguments that weren't raised at first instance may be unfair, and your point that it's inconvenient if we can't, for the reasons you give. What I'm totally at sea at is what this injunction has to do with anything about that at all.
We say, with respect, it doesn't have anything to do with it.
It seems to me that those points are both perfectly valid. The points so far I've summarised as understood are perfectly valid, but
the reason
I think the injunction's irrelevant.
No, the reason it doesn't have anything to do with it is that before you find someone guilty of the statutory tort, you have to identify the adjustment that they failed to make. Without understanding what adjustment it was that it is said they were required to make, you can't make a finding that they are guilty of the statutory tort.
I mean, if we think we shouldn't deal with certain arguments that you've raised, we either have to make it clear that our decision is based on the arguments that have been raised and can be raised, or maybe we have to send it back. But the injunction seems to me irrelevant.
Exactly. We respectfully agree with that. My lords, my lady, what happened then was that FirstGroup appealed to the Court of Appeal, and as I've said, by that time there was already a judgment in black.
Yes.
That had also been appealed to the Court of Appeal, and as you'll see from MS 329, the two cases were joined. Now, First Group's grounds of appeals went in, and it was then, of course, open to the respondent to put in a respondent's notice. There is, in fact, in the bundle, a document headed respondent's notice, which the appellant put in. That's at 348. But it wasn't what we would normally refer to as a respondent's notice, because as you can see from page 348, grounds for upholding the appeal or upholding the order, we intend to rely on the reasons given in the judgment. So there was an express indication that there was to be no attempt to rely on anything other than what was in the recorder's judgment. Then at 356, you can see how the point was put by my learned friend in his skeleton argument for the Court of Appeal. At paragraph 5.
Page, sorry.
356.
Thank you.
He said this: initially 15 adjustments had been identified, but the particulars of claim were amended, and then at trial, reliance was focused upon one adjustment, a change to the appellant's policy so that users of the bus service are required, rather than merely requested, to vacate the wheelchair space. Now, we say that in those circumstances, that was the requirement whose reasonableness was in issue before the Court of Appeal and also before this court. The question before the Court of Appeal was whether the recorder was wrong to hold that that particular adjustment was reasonable. And we say he was wrong because the adjustment fails to strike the right balance between the interests of wheelchair users and the interests of other legitimate users of the space, would lead to confrontation and delay, and would legally and in any event practically be difficult or impossible to enforce.
One of the troubles is to know what's meant by required.
Well, indeed, we respectfully submit that is why the recorder and the Court of Appeal were both right to understand that the essence of what was being suggested was indeed a policy which ultimately would have to be enforced. If it doesn't mean that, and as I've shown you, that's the word that the recorder used at paragraph 15 and also at paragraph 21. If it doesn't mean a policy which ultimately would result in enforcement, what does it mean?
Whose duty was it to show whether the form of policy pursued by Lothian and Stagecoach was or was not efficacious? The appellant put it in before the recorder, and the recorder relied on it as an instance. We're now asking questions, well, how practical would it be? How much of a difference, if any, has that has Stagecoach experienced by comparison with others? There's a paucity of evidence. Who had the responsibility? Was it their obligation on putting it in to demonstrate its effectiveness, or was it your obligation to demonstrate that it was no more effective than any other policy?
Well, as a general matter, once an adjustment has been identified, it's the defendant whose job it is to disprove its reasonableness. But that is not to say, the very specific question that your Lordship asks is about the policies of other bus companies. Now, I'm going to come to deal with those in some detail in a moment, and our submission will be, in due course, that there was no evidence before the recorder on which he could conclude that any of those bus companies actually enforces a requirement of this kind.
Well,
simply the evidence wasn't there.
Was it for him to try and collate all that evidence? In which case, one could see a practical difficulty. Somebody who's a person with disability, not with large funds, having to get that sort of evidence before the court, or was it the duty of the bus company to demonstrate its ineffectiveness.
I'm going to answer that point by reference to the detailed policies in just a moment, but
Right.
we do say that although in general terms it was for FirstGroup to negative the reasonableness of the adjustment identified, that's a general answer to your Lordship's question. The burden of proof on reasonableness was on us, but it was not open, that did not mean that it was open to the recorder to reach findings that there were policies with teeth that were enforced, in fact, when there was no evidence before him at all of any bus company that actually enforced this requirement. So that's, I hope, a compendious answer to your Lordship's question. Can I move to my second heading, which is the legal framework of the Equality Act, and hopefully do this relatively quickly? There are 5 key points that we make about the law under the Equality Act. The first is that the duty to make reasonable adjustments is anticipatory in the sense that it is owed to disabled persons at large, or in this case a category of them, namely disabled wheelchair users. That can be seen from a judgment of the Court of Appeal, which you have in a case called Finnegan. The judgment is in the First Authorities bundle, tab 5, MS 1037. And it's paragraphs 32 and 33.
Yep.
I'm not going to go in detail into the facts of this case, but it was essentially being alleged against the police that they were under an obligation to provide a British Sign Language interpreter when they attended at an address investigating an offence. One can see from 32 and 33, not in dispute that the duty to make reasonable adjustments is anticipatory, owed to disabled persons at large. Follows that the Chief Constable was obliged to make reasonable adjustments to her PPP, that was the terminology then, it's now PCP, of conducting searches in spoken English, so it did not have a detrimental effect on deaf persons. It's clear that this duty could not be discharged by treating everyone as individuals and adopting communication styles to suit the circumstances of the particular case on an ad hoc basis. The anticipatory nature of the duty is inimical to the idea that reasonable adjustments may be made by deciding on an individual basis to conduct a search with or without a BSL interpreter in attendance or on standby according to the exigencies of the particular situation. And then at 36 at the bottom, one can see that it's important to keep in mind the distinction between anticipatory changes to a PPP, which are applicable to a category or subcategory of disabled persons, and changes which are applied to individual disabled persons on an ad hoc basis. The duty to adjust a PPP is to be judged by reference to the former, not the latter. So the point being made there is that when you suggest a reasonable adjustment, you are suggesting a reasonable adjustment to a practice or policy. So what you have to suggest is an adjustment to a generally applicable policy. The second point we make is that the appellant had to show that as a result of the failure to make the general adjustment contended for, he was personally subjected to a detriment within the meaning of section 29(2)(c). The appellant appears, as we understand him, to accept this, see paragraph 96 of his case, at MS page 79. In any event, it's clear from the last sentence of the same judgment, paragraph 45, Finnegan.
Sorry, what page?
1039.
Yes, thank you.
The Chief Constable's failure to adjust her PPP caused no detriment to Mr. Finnegan. This finding is fatal to his claim. Now, that's why one of the reasons why I say it was very important for the court to identify the precise adjustment. They had to identify the precise adjustment, and we say the precise adjustment was indeed a blanket rule that whoever is occupying the wheelchair space must give it up, whatever the reason. Otherwise, if the adjustment had been something less than that, there would then have been an issue as to whether the failure to make that adjustment gave rise to a detriment in this case. And we know that the recorder found that it did, because he awarded damages. So that's a second answer, perhaps I'm coming to it late, to my Lord Toulson's question. Would it have been open at some later stage to say, well, actually, perhaps the rule could be hedged about with exceptions? The answer is no, it wouldn't. The rule had to be apparent and it had to be identified at the stage when liability was determined. The third point is that the burden of proof on the question of reasonableness shifts to the respondent, but only once a potentially reasonable adjustment has been identified, and we get that from paragraph 38 of the same judgment of Lord Dyson in the same case.
Thank you.
Here, the adjustment which emerged from the discourse before the recorder was that identified in paragraph 21 of his judgment, and that is the adjustment whose reasonableness it fell to FirstGroup to disprove. The fourth question is how
does that actually work? A potentially reasonable adjustment has been identified.
Yes.
He's got to show it's an adjustment, and he's got to show it's potentially reasonable.
And we accept that that's satisfied here. He identified an adjustment. It was a perfectly clearly identified adjustment. The adjustment is whenever a disabled person in a wheelchair wants to board the bus, they must be allowed to do so, if necessary, by requiring the person occupying the space to vacate it.
That satisfies the test of potentially reasonable adjustment.
It's potentially reasonable.
Fine.
It's a low test.
Fine, okay.
I think if something utterly ridiculous had been suggested, perhaps the burden wouldn't have shifted.
Yep.
We don't need to get into that in this case. It was potentially reasonable. The respondent had to answer it. So the fourth point of law is that what is reasonable involves a multifactorial assessment. Some of the relevant factors are set out in the EHRC code, which you have in volume 5, the supplemental volume, and that's at supplemental MS, page supplemental MS, sup MS, page 102. One can see that the factors include whether taking any particular steps.
Sorry, I'm not sure I've got this. Maybe I left it behind.
Authorities, volume 5.
It went in late, I think, because
Authorities, volume 5.
it was noticed at a late stage that the
I'll find it over the
wrong
lunch.
version.
I think we have it on email, but not electronically.
I think it's Learned Usher has it.
Right, I apologise. Perfectly obvious I haven't looked at it.
It was sent by email, Mr. Chamberlain, was it?
It was, yes. So,
And when was the email? On what date?
I don't know, because I think it was sent by the
It would have been sent
by the
email,
appellant.
I think.
It was a mistake by those who were compiling the bundle that the wrong version was put in volume 4. Probably would have been sent yesterday, Paul, I think, or possibly a few days ago.
We had something on Monday, but I think that was simply supplementary authority volume. Yes.
Well, it's a very short point. And
Monday
perhaps I
at
can-
9:24.
I'm very
Yes,
happy.
Monday,
Robert
9:24.
Greenberg.
We can lend.
It's Monday at 9:24.
What page are you on?
102.
I appreciate that's not much good for those who haven't got a copy.
No.
You have mine, because I've got it electronically. Is that your assumption? I've got one.
My lady, if it helps, it's extracted in our written case.
Have you got one? Sorry, I did it. You've got, everyone's got one.
But if it's in the written case.
Let me hand Lord Reed's. I've got it electronically. Yep.
Oh, I've now got it electronically.
Yes. It's a checklist of bullet points.
Having bossily done all that, I've lost the page number. Which
I'm sorry, 102.
Thank you.
It's a checklist of bullet points, and it says, without intending to be exhaustive, the following are some of the factors which might be taken into account when considering what is reasonable.
Yeah.
The first is whether taking any particular steps would be effective in overcoming the substantial disadvantage. The second is the extent to which it is practicable for the service provider to take the steps. And the fourth, relevant here, the extent of any disruption which taking the steps would cause.
Right. Yep.
Now, the fifth legal point is that it is an important aspect of reasonableness to consider the impact of a proposed adjustment on third parties. You might say that the impact on third parties is an aspect of practicability and disruption, but it is in any event stated in terms in the judgment of Lord Justice Buxton in a case called Roads and Central Trains, which you have in the first bundle of authorities, tab 13, MS 1158. And it's paragraph 42, the bottom of the page, an ultimate sentence. Steps might be unreasonable for a person to take if they unreasonably impact on third parties.
Sorry, which paragraph was it?
42, second sentence, third sentence. Now, we don't understand that point to be in dispute, but we do say that the recorder's judgment indicates that he hadn't properly grasped it. And when one looks at his judgment, it's in MS 322 at paragraph 21. He deals with the impact on third parties at the bottom of paragraph 21. He says, although such a policy might inconvenience a mother with a buggy, that, I'm afraid, is a consequence of the protection which Parliament has chosen to give to disabled wheelchair users and not to non-disabled mothers with buggies. So that's what he said. Now, Lord Justice Lewison dealt with that point in the Court of Appeal, and we would respectfully submit correctly at paragraph 56 on MS 296. And he said this. Finally, he says, I must comment on the judge's statement that inconvenience to mothers with buggies is a consequence of the protection that Parliament has chosen to give to disabled wheelchair users and not to non-disabled mothers with buggies. This was, in my judgment, a misapprehension. What Parliament has given by way of protection over and above the conduct regulations is a right to reasonable adjustments. What is a reasonable adjustment depends, among other things, on the impact of the adjustment on others. They do not need to have any particular protection in order for the impact on them to be given weight. The judge seems to me to have thought that the needs of wheelchair users trumped all other considerations. If that is what he meant, I respectfully disagree. So he's simply making the point there in my submission that one has to give effect to the principle that the impact on third parties is relevant. And one can't give effect to that if one uses as a conclusion the fact that one category of persons is accorded protection under the disability provisions of the Equality Act and another category not.
But the fact that you take into account in your overall assessment of reasonableness the impact upon other people seems a pretty uncontroversial statement. Mr. Allen will tell us if it is controversial, does not mean that you don't also take into account the fact that specific statutory protection is being given to a certain sort of person. So that when you are looking at the interests of two sorts of persons, it is surely relevant to take into account that one enjoys special statutory protection and the other does not.
I agree, but if your answer to the inconvenience that the adjustment you've identified will cause to third parties is the answer that the recorder gave here, then that does, with respect, indicate a misapprehension or misunderstanding on his part.
But it depends how you interpret what the recorder said.
Yeah.
I mean, there are two distinctly possible interpretations. One that he discounted it entirely and simply said that this was the consequence. The other is the interpretation suggested by my lady, that in deciding whether it's a reasonable adjustment and in deciding whether the impact on the third parties is reasonable, it's proper to take into account the fact that statutory protection has been given.
Well, my lord, I can understand that, but when one looks at the rest of the judgment, one doesn't actually see a grappling with the impact on third parties at all, other than in that sentence.
We'll come to that, no doubt, but it is significant that Lord Justice Lewison, in dealing with this, expressed himself conditionally.
He did. He said if that is what he meant, he was wrong. What he was doing was he was identifying a passage in the judgment which seemed to him to give rise to the conclusion that there'd been a misapprehension on the recorder's part. And we would respectfully submit that when one looks at the judgment as a whole, and I accept one does have to look at the judgment as a whole, one doesn't see any other passage where he has taken into account this impact as he should have done.
Well, if there's any other passage in judgment we'll take us to specifically in connection with this point, perhaps we can do it after the short adjournment. Shall we resume again at 2 o'clock then, at a convenient moment? Thank you very much. Court's now adjourned.